If you have a small business in the Cayman Islands, you would have noticed an increase in the regulations affecting your business. One of these regulations is the anti-money laundering regulations. Regulations are being beefed up to comply with the requirements of the Financial Action Task Force. Small businesses, including small Caymanian law firms, must also comply. In order to assist Cayman law firms to comply with international standards for anti-money laundering, the Caribbean Financial Action Task Force made a recommendation. That recommendation was that a supervisory authority be established for law firms to supervise law firm compliance with AML regulations. In order to achieve this, the government of the Cayman Islands made an amendment to the anti-money laundering regulations. This amendment stated that a public body or a self-regulatory body be created by the Cabinet of the Cayman Islands Government for firms of attorneys that engage in relevant financial business. According to the website of the Cayman Islands Legal Practitioners Association, otherwise known as CILPA, CILPA was named as a supervisory authority for monitoring AML compliance by firms of attorneys at law within the Cayman Islands. When we look at the structure of the Cayman Islands Legal Practitioners Association, we note that it was formed as a corporate entity. The membership of that entity consists of lawyers of various law firms. That entity also created a board of directors, which in turn created one or more committees. Now, this committee became known as Cayman Attorneys Regulatory Authority, otherwise known as CARA. In order for the CARA committee to work, that committee was delegated certain functions. One of the functions of the board of directors that was delegated to the CARA committee was the AML supervisory function. However, as we all know, the delegation of functions to the CARA committee does not remove the board's responsibility for the overall supervision of the committee and the proper discharge of the board's ultimate responsibility. Because the CARA committee is under the ultimate supervision and control of the board of directors of the Cayman Islands Legal Practitioners Association, which consists of competing law firm partners, the CARA committee faces several issues. One issue is the fact that the CARA committee is not legally independent of the board of directors of the Cayman Islands Legal Practitioners Association. This may lead to conflicts of interest in the discharge of the functions of the CARA committee in favor of the large law firm representatives sitting on the board of directors. Since the CARA committee is not legally independent of the board of directors of the Cayman Islands Legal Practitioners Association, it may share information gained on AML inspections with the CILPA board, breaching client confidentiality and data protection rules. In addition, because the CARA committee may share information with competing law firm partners who sit on the board of the directors of Cayman Legal Practitioners Association, legal professional privilege could be lost. This is an important aspect of the right to a person's private life and correspondence guaranteed under the Cayman Constitution. The structure of the AML Supervisory Authority for Lawyers also threatens the right of freedom of association under the Cayman Constitution. Some small Caymanian law firms who have concerns over the conflicted nature of the CARA committee do not wish to register with CARA but are being forced to do so, notwithstanding its conflicts of interest. Because the CARA committee is not legally independent of the board of directors of the Cayman Islands Legal Practitioners Association, there is also a concern that the money laundering regulations could be breached for the offense of tipping off if a member of the CARA committee became aware of an AML investigation and disclosed that fact to a large law firm member under investigation. It is unclear why the government of the Cayman Islands allows such conflicts of interest to exist. It is also unclear why the government allowed laws to be amended to permit lawyers to regulate themselves, notwithstanding the inescapable conflicts of interest. Although small Caymanian law firms have raised these concerns and wish to be regulated by an independent regulatory body, these concerns appear to be largely ignored. In fact, small Caymanian law firms are now being hit with a $100,000 enforcement fine for asking these questions about these conflicts of interest. If the AML Regulatory Authority for Lawyers is allowed to operate with such conflicts of interest and drive small Caymanian law firms out of business, This could set a precedent for the operation of other small Caymanian businesses in other sectors. Now, small Caymanian law firms are faced with a challenge: fight against a conflict of interest and go out of business while doing so, or give in to the conflicts and ruin their integrity. If the Cayman Islands government wishes to demonstrate good governance, it must address the issues of small Caymanian law firms regarding conflicts of interest. It can't pretend that the issues don't exist and sweep them under the mat. We must take a stand and stop being silent about conflicts of interest. We must blow the whistle on inappropriate matters and choose a system of integrity. The AML Supervisory Authority for Lawyers must be replaced by an independent legal entity or a public body subject to the Public Authorities Law.